everybody would please quiet down, we'll get started now. I am Catherine Cheney. I invited the Secretary of State here last Thursday to come to Dover and present some information regarding the final order from the hearing officers Donald Mitchell regarding the LGC and the orders pursuant to that. I'd like to thank David Lang, President of the Hampshire Professional Firefighters Association, for his diligence and perseverance on this to get this to this point. And I'd like to thank other town officials that are here tonight for coming. Eileen Latterman, Chairman from the Hampton Municipal Budget Committee, Mary Louise Wolski, the Vice Chair from that committee, Representative Lawrence Perkins from Seabrook, here in the front, Selectman Ed Hess, also from Seabrook, and Joe Tiltone, Seabrook Interim Acting Town Manager. I also would like to recognize the Dover City Councilors that are here tonight present. We have the Deputy Mayor, Bob Carrier, the Mayor, Dean Trefethan, Councilor and Representative Dorothea Hooper, Representative and Councilor Michael Whedon, the City Manager Mike Doyle, and Councilor Karen Weston. One of the striking differences of Dover is that we had actually passed a resolution. Councilor Weston and I co-sponsored a resolution asking the Secretary of State. It's called the Appeal to Regulator for Insurance Premium Refund. So we had sent this to the Secretary of State in February asking for their help in recovering our funds that we felt the LGC had and owed us. At this time, I would just like to thank everyone for coming, and I hope for a very informative evening, and I'm going to pass this over to the Secretary of State, Mr. William Gardner. Thank you.
Thank you, Councilor Cheney, for making this event happen. I have to say that a few years ago, the councilor called and asked if I would come over to Dover and speak to a group of Boy Scouts, and the timing wasn't right for it. She wanted me to speak about voting in the presidential primary, so I always have felt that I sort of owed her something for not doing that. But I'm not going to count tonight as at that. What we're going to try to do tonight is just go through in a way that hopefully will add some something beneficial to this, to what has happened. And we have some from the Bureau. Following me will be Special Counsel Andrew Valinsky, and at the end we will stay to take whatever questions any of you might have. This is not a simple matter, but there's a lot at stake for a lot of members and the individuals of those members. So I'm going to start with, I think the best way, there had been an entity called the New Hampshire Municipal Association, and its purpose was to be an association that the towns could be members of and talk about issues that are important to the cities and towns before the legislature and to lobby on their behalf. In 1984, what was called the New Hampshire Municipal Association, Inc. was a nonprofit entity. And they created in 1984 what was the beginning of the pooled risk management program that was called New Hampshire Municipal Association Health Insurance Trust, Inc. And they did that so that they could begin what we know of today as the health trust and the pooled program for health that has expanded to other programs. So, but as they did that, and it was beginning also in other places in the country, there became questions about whether they should pay taxes, what kind of taxes, how should they be treated, were these really insurance businesses? And so after a year or so of those kinds of discussions, the Hampshire Municipal Association decided to bring before the legislature legislation that would sort of define what these pooled risk programs could actually do. And the legislation was written by the director of the New Hampshire Municipal Association. It was someone from the board who presented it. There was a public hearing, some public hearings in the legislature, and it was debated and discussed, and there's transcripts of those discussions that were held before the committee. And at the very end, there was the insurance commissioner at the time, who had been a state senator from Rochester, Louis Bergeron. He had served in the state senate in the early 80s, and then he became insurance commissioner. And as I said, these were some of the key issues. Should this be regulated by the insurance department? Should this have some oversight by the insurance department? And how would they actually file reports annually? What would they have to do? So the plan was that they would have to file those reports with the Department of Insurance, but that there would be no oversight and no regulation, and and they put into the legislation a sentence that said, this entity is not an insurance company. So this pool risk program is not an insurance company, but it will report to the insurance department once a year. The insurance commissioner at the time, as I mentioned, Louis Bergeron, he got up at the hearing and he said, I'm against this, because if there's reporting to the insurance department, the public are going to think that there's some regulation here. The public's going to think that somebody is looking over this entity. And if you're not going to give any oversight or have regulation, then I think that's wrong for the public to be made to think that there is something by filing, because everybody else that files because we're the regulator. So he was asked, well, what do we do? What do you want us to do? And he said, well, put it in the Secretary of State's office. Put it there, because just like any other corporation, they'll file once a year, but that's it. It doesn't mean, they just file a very rudimentary filing and just do it there. And so that's what they did. And at the very end of this transcript on this hearing, this is what he said. This is what he told the committee in 1987, that if you do this, someday someone's going to walk out with a pot, it was saying like a pot of gold, and nobody's going to know how it happened. And that was his warning that he made in 1987. So the legislature ended up passing that legislation that created 5B. And so for the next 15 years, there were filings, but there was no oversight and no regulatory authority. So you had the NHMA, that was the original New Hampshire Municipal Association. You had the New Hampshire Municipal Association Health Insurance Trust, Inc., a not-for-profit, and you had New Hampshire NHMA Property Liability Trust, also a not-for-profit, and they created LGC Inc., which was sort of a holding company. And that was set up in 1988. And at that point, there were boards. Now, why were these nonprofits? These were nonprofits because a nonprofit, by state law, is an entity that is created for the public good, an entity that does something good for society. And the idea that the Health Insurance Trust was to do something good for society. And that good was to have the insurance rates as low as possible for those cities and towns in the state that were interested in pooling together to come up with something that would be beneficial for them and others. And that's what a nonprofit, that's what's behind a nonprofit and why nonprofits are given some special privileges. In this case, because this New Hampshire NHMA Health Insurance Trust, by law, was given the privilege that they would be exempt from all taxation. So they were exempt from all state taxation, compared to an insurance company that is regulated by the insurance department. They were going to be something, and this was for the public good. This was to try to get the rates as low as possible and help as many people as possible. So now you have this, and we as we go ahead, as we move for the next few years, there becomes a question about what kind of entity are these again. And we get to 2000, if you go to the next, okay, we get to this. In 2002 and 2003, there were discussions within the boards that existed. That prior, I showed you the 4 different entities, they had 4 boards, and there was a discussion to eliminate the boards and make one board. So you could take the health trust and the property liability, eliminate the boards, and have one board. And that was the intent. So in April of 2003, there was a vote by the boards to actually do that, to eliminate themselves as a board and have one board, the LGC board. On June 11th, 2003, at what the chairman of the board at the time, Keith Burr, said at the very end of the meeting, "This is our last meeting as Health Trust Board of Trustees." And that board never met again until a few members of it back last fall in 2011. So from that meeting until 2011, that entity, that board, Health Trust Inc., did not meet. Now, why? Well, after the June 11th meeting, and as I mentioned, in 2 months before that, they had voted to have just to sort of dissolve. They ended up, that entity ended up trying to merge with a limited liability company in New Hampshire that is a for-profit company. And when they did, on June 25th, they were told that they could not do that that was not legal under New Hampshire law. You cannot merge a nonprofit with a for-profit. You can only merge a New Hampshire nonprofit with another New Hampshire nonprofit that is, by law, under Chapter 292 of our RSAs, or an out-of-state nonprofit that is registered in New Hampshire as a foreign corporation under that same chapter. That's all. So they were told that by the corporate division of the Secretary of State's office. on June 25th. At the same time, they wanted the Attorney General's office to weigh in about it, because they questioned what we had said. Attorney General's office said the same thing. They said, you cannot do this. This is illegal in New Hampshire. You cannot take a nonprofit and merge it with a for-profit. As I mentioned earlier, some of the benefits that go with nonprofits. Nonprofits are given certain things that all the people share in giving to them. And you just don't take them and then give them to a for-profit entity, because they have benefited from things that for-profits don't have. So what happened? The next day, after they were told by both officers that this is illegal, on June 26th, they this is what they do. They do exactly what they tried to do the day before and were told no, by setting up 2 new limited liability companies in Delaware and 2 new limited liability companies in New Hampshire. They set them up on June 26th, the next day, and they then took NHMA. You can see how they eliminated it, created this LGC and LGC Real Estate Inc., and they took Health Trust and they merged it into the Delaware company that they had created the day before. They merged it into LGC HT in Delaware. And when they did that, the documents that they filed in Delaware didn't say that it was a not-for-profit in New Hampshire. The documents show they called it a statutory trust, that they were merging a statutory trust into this LLC in Delaware. And they did the same thing with property liability trust. Now they did that, they merged it on the 26th, and then on the 27th, the next day, they took the LGCHT that had been merged with the Health Trust nonprofit in New Hampshire and moved it back from Delaware, did it in Delaware, then moved it back the next day into New Hampshire as LGC Health Trust LLC. So what they did in 2 days was exactly what they had been told by the corporate division of the Secretary of State's office and the Attorney General's office back on June 25th in 2003 that they couldn't do. So they effectively did it anyway by going to another state and saying that they were a statutory trust, and then coming back to New Hampshire. So now you have this on June 27th. Now you say, how could that have happened? Well, by New Hampshire law, any nonprofit that merges has to notify the Secretary of State, or the merger is not effective. You also have to notify the city or town clerk in the city or town where they're principally doing business. That did not happen. So New Hampshire never knew that Health Trust was merged into that Delaware LLC. And because they didn't do that, it was not an effective merger anyway. So, but it continued. And then in Delaware, the same thing happened. They never told Delaware that they merged the Delaware LLC into a new New Hampshire LLC. So Delaware didn't know either. So for the next 3 years, Health Trust Inc., as a nonprofit that the board met I mentioned on June 11th for the last time, that continued to exist for 3.5 more years. The entity in Delaware continued to exist for almost the same amount of time, and the new entity in New Hampshire existed. So for 3.5 years, you had all three entities supposedly legally existing, because they never actually affected the merger, even though they were operating as if they had affected the merger. So what do you have? You have in 2006, now 2005, now, there's a period of time that a nonprofit can be registered, and then they're sent notice. And it's usually 5 years, but when they first register, it could be 2 or 3 years, depending on the 5-year cycle. So they were sent, Health Trust was sent in 2005 a notice that they were going to be administratively dissolved by the corporate division of the Secretary of State's office because they did not file their papers that they have to do every 5-year cycle. So when that happened, a notice was sent to the Health Trust, and that notice, after it was sent, came back with this letter. January 12, 2005, please be advised that the above company was dissolved on July 1st, 2003. If successor, Local Government Center Health Trust, has filed its annual report, please advise if there's any other necessary information. So when that came back, they were dissolved. So Health Trust got officially dissolved in the end of 2005, and the same with the property liability. And what happened was, they thought that the Delaware LLCs had been dissolved at the time of the merger. They realized, they found out, because Delaware does the same thing, that they had not dissolved, I mean, that they were still existing. And so the state of Delaware, after a few years, based on their law, they dissolved those two entities, the two LLCs that they thought, the LGC thought had been dissolved 3 years earlier. So now you have two states acting independently and dissolving these entities. So what happens? Well, the LGC decides that they need to revive the Delaware corporations, because they need to revive them, because during the years that they hadn't dissolved them, they had to pay fees and administrative expenses. So they had to revive them, pay off the fees and expenses, and then dissolve them, which they did. And so now they went away, and the two up above, their original Health Trust Inc. went away. So they were operating with the LGC Health Trust LLC and LG Property Liability Trust LLC. Now, when the legislature granted this, for the first time, this regulatory authority, and that was quite a battle in 2009 and 2010, because the LGC was not supportive of the legislation. They didn't think that they should have this oversight. The very first year, that was their position. The legislature passed legislation saying that the Bureau of Security would have the oversight. The second year, the LGC changed its position and said, okay, we're going to go with regulation, but we're opposed to it being in the Bureau of Security. It should be in insurance. And that was their position until the insurance commissioner came out and said, no, we're not going to accept that. I mean, it was for the same reasons as back in 1987. We're not going to accept that. And so that changed. Well, what happened in 2009 was that when the Bureau was given the authority, immediately there was a challenge. And one of the things was that LGC wanted to know who the person was who filed the complaint. And the Bureau staff said that that's given out, but it's not given out until there's a proceeding. And there was, the bottom line was that even though there was a filing in court not to comply with it. So we had to defend why the legislature meant what it said in the law. And if you were to read the lawsuit, that's what was said to the court, that the legislature did not mean this. They didn't mean to do this. So the judge got a copy of the Senate Journal, where everything that's said on the floor of the Senate is printed and available. So you can listen to the debate on any piece of legislation if there is a debate. And there was a debate. So they knew what the senators were thinking when they did this. And on the House side, there's a calendar, the committee writes why they support a certain piece of legislation, and that was. So after 5.5 months, that became, that got taken out of the judge let it go. So we would have that authority, and then in 2010, it came back again, and the legislature decided to even strengthen the regulation. So now we start on this, and one of the first report that was issued, we talked about the corporate structure, and that there was a problem with the corporate structure, and why. And in between all this, from 2003 until 2009, there were these 2 court cases brought by the firefighters, right to know cases. And both of them, the Supreme Court, on 2 different occasions, 2 different years, ruled that these organizations were governmental entities, and they had to respond to right to know requests. And the first one was done in 2003. And so there is a question about why did this all begin in 2003? Why were they so determined to accomplish what they had been told was illegal in New Hampshire to go to Delaware? Well, in all the testimony that's been given, the board of LGC has said repeatedly none of them knew that they went to Delaware. And at the hearing, the 10-day hearing, and I would suggest that any of you, if you really want to get everything that was said and not one side's view versus another side's view, listen to it yourself. The certified, this is done by an independent, and the transcript is certified, done by independent. It has everything, every word from the beginning to the end. And if you, that's something that you have the opportunity, if you wish to listen to it, to listen to those days and come to the conclusion yourself about this. And that's it. The 10 days had everything in it. So we ended up, we really couldn't say about different things that we had seen and gotten while the proceedings were going on, but now that there's been a final order, anything in that final order and all of the material that we have, and there are volumes that are maybe come to about 6 feet long of documentation, all documents that were used in this case by one side or the other. And all of that is open to everyone. That's what will be sent if this matter goes to the Supreme Court. They will get all of that. Now, how did it start? How did all of this start for the securities? This is my last part of this. Sometime in 2008. If you look back to this time 4 years ago, because the convention starting in Florida. Think about it. It was McCain and Barack Obama 4 years ago. Think about that time. At that time, some legislators came into my office one day and they said, "Do you know about this?" There were 2 different magazines that listed the biggest public entity risk pools in the country. And if you look, the biggest in the country is in New Hampshire. It's bigger than California. It's bigger than Texas. It's the biggest. Over 300 million in member contributions. And there was a second magazine that also covered this and had it in 3rd place. And I looked at it. I had no, my goodness. Now think about the time in 2008. That's when Lehman Brothers went down. That's when AIG, there was a lot of concern that the financial system was freezing up. What was happening here? Why was this happening? How was it happening? How could you have these big entities? And this is what happened. There's a guy from New Hampshire, Paul Montrone, who is one of the top financiers in the state. And he walked into my office in the fall, early fall of 2008. And I asked him the question about Lehman Brothers, AIG, the big banks, what was happening. I said, "Do you understand what's happening, Paul?" And he said, "Bill, I understand what's happening with the banks." But he said, "It's really worrying me about AIG. I don't understand that insurance conglomerate and I'm worried about that." So that is at the same time that we get to see this. So you can see that now, you know, how did anybody in the state know that we had something that was handling this kind of money that was all public? And so I mentioned it to the Bureau of Securities Regulation Director. And it was in the spring of 2009 that at a Senate committee hearing, they were talking about financial regulation. And he brought this up as an example, that this was something created by the legislature back in 1987, and if something were to go wrong, who would people blame? Particularly if there was no oversight and regulation. And that led to some of the research about how this was created in the first place, and that language from the insurance commissioner saying if something happens. So you can see how people in the legislature at that time were concerned, what if something happened? People are going to, well, we created an entity with absolutely no oversight, exempt from taxation, no regulation, and there was a report that had to be filed once a year, but there wasn't anything, as long as it was filed, that you couldn't do anything to actually challenge anything that was in it. So there was nobody really could do anything. So that's how it started, and which led to this legislature acting the second time, making the law a little stronger, and then and for the Bureau, in the last 6 months, the Bureau has come to settlements with Primex and with School Care, basically along the same lines as the report from the hearings officer. But I'm going to let, at this point, I think that I'll probably let our special counsel talk about, and I know you want to get into how much. But it's not all, you know, it's not there until it's there. But our special counsel, Andy Valinsky, will take it from there, and we will answer. There are documents for all of this, and we are not. This is anyway. We'll welcome anyone that has a question or a point of view. So, Andy, why don't you come up? Andy's the one who, at the the 10-day hearing sort of did the work beforehand with the depositions, and you'll see if you have the time sometime to look at those hearings, because you can watch them. They were live streamed when they were done, and they're on our website, and it's listed day by day who the speakers were, who were on the stand each day, and everything was done under oath, and all the backup documents, now that there's a final order, can now be talked about.
Thank you, Bill. Let me warn you before you go run out and watch the internet recordings of our trial. There was one camera, it was stationary, and it was focused on my bald spot right here the whole trial. So it may not be the most exciting trial to watch. Let me just pick up somewhat where Bill left off, tell you a little bit about the hearing officer's order, what it means, what he found, and a little bit about how we got there. But first, let's do Risk Pool 101. So before 2003, there were separate entities that insured workers' comp, property liability, and health. They each had their own board. The statute that created, that affirmed the existence of risk pools was pretty clear that each risk pool had to have its own board and its own set of bylaws. One board, one bylaw, one risk pool. The statute doesn't have a lot of standards in it, but that's pretty clear standard. So the LGC predecessor was organized in that way prior to all the machinations you saw with the animated slides with Bill's presentation. The other thing that the statute said, which is in keeping with the purpose of risk pools, is that they're pooling nonprofit arrangements. So the statute provided that pools have to return surplus, which is administrative costs, claims, and reinsurance. Anything over that is surplus, and it needs to get returned to its members. So it's one of the other few standards in RSA 5B, but it's a pretty clear standard. And it's also pretty clear that it needs to be done annually. Until 2009, no one had supervision over the risk pools. In 2009, the Secretary of State, Bureau of Securities started to get it, and then in 2010 it was enhanced. And the members of the Bureau, some of whom are here, did the investigation and participated in the trial. I'm a Johnny-come-lately, I just helped with the trial. So they're the ones responsible for putting this together. But a lot of the initial information came from these right-to-know requests that were filed by David Lang and the professional firefighters. And they deserve a lot of credit. And I would give it to them. So an interesting sidelight, not in the hearing officer's order, as Secretary Gardner mentioned, multiple trips to the New Hampshire Supreme Court to effectuate the right-to-know requests that the firefighters had filed, and that the local government center resisted, saying they weren't a governmental agency and therefore they were not subject to the right-to-know. Okay? That's not the funny part. Here's the ironic part. At the same time that they were litigating in Merrimack County and in the New Hampshire Supreme Court saying the right-to-know law does not apply to risk pools, John Andrews, the executive director of the local government center, was sending right-to-know demands to Primex, the competitive risk pool, to get their information. How many hundreds of thousands of dollars did the LGC spend litigating the right to know fight at the same time they were using that tool against their competitor Primex? That's one of the issues. It's not addressed by the hearing officer because it doesn't relate to the organization or the surplus. So one might wonder why you would go through all those machinations to reorganize. I know Adrian's got his finger on the button, not yet. It became clear, and we'll discuss this as it comes up in the order, that once the LGC was reorganized, they got rid of the individual boards. They placed health, workers' comp, and property liability under one board with one set of bylaws. Not every municipality or school district is a member of all three programs. So you had the biggest program, which is health. Decisions were made with health trust assets to support other programs. And that support was facilitated by using this parent subsidy model, so that each of the programs, in effect, gave money north to the parent, and then the parent swapped it around between the programs. Health Trust, being the largest, gave millions and millions of dollars each year from 03 to 10 that the parent then transferred to workers' comp. Workers' comp on paper gave $4,000, $6,000, $10,000 in its contribution to the parent. It was nothing by comparison. Why did they want to support workers' comp so much? The numbers really show that it wasn't a financially viable program. But the minutes, and they had an executive assistant at LGC who took the best minutes. They were like verbatim, and we got to read thousands and thousands of pages. Sandy Wingate read them in the first instance. Those minutes showed that the LGC boards considered Primex a threat. And Primex's strongest program was workers' comp. So LGC started subsidizing its own workers' comp program so that it would compete against the Primex program. Different places in their minutes, and we put these minutes in the record, and they're in the materials that the Secretary talked about online. Some of the minutes talk about how Primex acts without scruples, that they're unethical, they subsidize this program with that program's money, and then LGC said all in. And you'll see there was some $17, $18 million of subsidization of the failing workers' comp program. Okay, let's go, Adrian. So this is from the hearing officer's order, laying out what the Secretary has explained to you. The Secretary of State's office and then the Attorney General's office both explained that the reorganization that the LGC was proposing were not legal in New Hampshire. His finding, not ours. They did it anyway. Go ahead. Here's the result. They have to reorganize within 90 days. Now, if they appeal, they'll try to stay that order. And so you'd have to build in the time for an appeal before you come back to this 90-day period. But this order simply says do what the statute requires. You now have two pools. One of the other moves that the LGC did is the Department of Labor actually supervises the Workers' Comp Trust, not the Secretary. And hearing the testimony, the Department of Labor became concerned about the financial viability of the Workers' Comp program. So they formally merged it with property and liability so that you could mix the balance sheets together and bulk up the poor workers' comp balance sheet with what was a decent but small property liability program. Go ahead. One of the other things that the local government center does that neither of the other two risk pools do is they require membership in the lobbying arm of this enterprise, and that lobbying arm is the New Hampshire Municipal Association. Go ahead. Emery is Jenny Emery, who's a consistent year after year after year consultant that the LGC hires. She talked about the monopolistic tendencies of this kind of an organization. You can imagine in New Hampshire, when you have an organization that takes $300 to $400 million a year in healthcare premiums, is the largest in the nation, you can imagine what impact it has on competition. They were doing this, in Ms. Emery's opinion, to reinforce their position. Actually, as we were litigating this case before the hearing officer, the LGC was lobbying for changes in the law, including changes on how the hearing appeal would be conducted. Mandatory membership, this is a finding of the hearing officer. Dues to the NHMA total about $900,000 a year from municipalities around the state. About 300 of that goes to the LGC parent organization. Under his order, no longer can it be required that you have to join the lobbying group. Surplus. Remember I said one of the few standards, return your surplus. This is a chart from the trial and from the order. Some of you won't be able to see this, but essentially the local government center in its health program built its net assets. This isn't what's used for claims. This is like ballast on a ship. Its net assets from 03 was just shy of $25 million to 10 was almost $87 million. Now, remember the secretary mentioned the 08 meltdown of the financial markets. In 08, 09, 10, municipalities are taking a hit in reductions in their state monies. So at the same time that the municipal members are getting less money from the state, the LGC was maintaining this very large retained earnings. One of the curious things is in 09, going from 08 to 09, they had actually two surplus accounts. One that made it really obvious was something called undesignated, which meant it was the board's discretionary kind of fluff account. 08 to 09, when the secretary first started to get oversight authorities, that fund disappeared. $26 million. All of a sudden got spent, redistributed, etc., so that it's a slightly negative number now and the account doesn't exist anymore for all intents and purposes. Since 03, following the reorganization, the amount of health trust financial statements, member balance, designated and undesignated, increased by 350%. This board set a target to calculate how much retained earnings should be held in the business, and then exceeded it by 50 and 60%, and then used actuarial analysis to justify yet a whole second fund that we'll talk about in a second. Free excess is sometimes how they refer to it. This is the extra bump. So I don't want to get deep into actuarial science. It's worse than looking at my bald head. But they misused it to create a second fund that they didn't have a purpose to spend yet. So they bumped up the actuarial number by 0.5 that translated to about $7 million each year. And this is the language of the hearing officer, that it created an insult to the health trust member municipalities and school districts, because they could have used that $7 million to offset property taxes, to make sure teachers don't get laid off, to get better equipment for firefighters, to get extra hours for cops on the beat. The LGC kept the $7 million. That was the result of this arbitrary 0.5 RBC. All told, he found, based on the 2010 figures, because we don't have 2011 figures yet, they're late, 33 million. Yep, 33 million is to come back to member communities, and we're to figure out how to do that within 30 days, so by September 17th, unless perhaps there's an appeal, which I hear they're thinking about. Go ahead. There's a second chunk of money in a different program, the property and liability program, of 3.1 million. So members of that program get a return of that. Workers' comp, here's what I mentioned earlier. Go ahead. This is how much Health Trust contributed to the workers' comp program by sending money up to the parent and then down to workers' comp. So in 03 it was 4 million. In 06 it was over 4 million. 07 it was 4.5. 08 6.5 million. 09 4.4. 10 3.875 million in cash from member monies from health to parent back down to workers' comp. The thing that this doesn't show is that the realty at Triangle Drive in Concord is now worth about $10 million. The initial monies for that real estate came 75% from Health Trust, 25% from property liability. Over the years, Health Trust was the one that kept paying the money to expand and improve the real estate. That's not included in these figures. And all of the interest of Health Trust after 03 was deeded to LGC, and Health Trust pays rent just like the other participants there at Triangle Drive. So here are the hearing officer's findings. Chose to subsidize the workers' comp program. Our expert, Mike Kutu, who used to be a selectman in Northampton, he's a retired top-notch insurance executive, computed the amount of subsidies at $18.3 million because he put in the real estate money. The hearing officer ordered the return of $17.1 million because that's the LGC's number. As the LGC was facing scrutiny by the Bureau, the LGC board adopted a note that required workers' comp to repay $17 million to Health Trust. Only the note didn't have any payment terms and no interest. The current executive director is Maura Carroll. She was a respondent in the case. She was found not to be personally liable. Peter Curo was a board member. He was found not to be liable because everything he did was in the context of being a board member. We did not settle with either of them. We settled with another 7, 8 board members. We settled with the prior executive director, John Andrews. He took a bar from ever running another program like that. He had a no-work consulting contract, and he's agreed to return last year's and this year's $20,000 a year hits from that. Go ahead. We argued that membership in the LGC, this is a little technical, is a security subject to security regulation. Hearing officer ruled against us on that. I think because he thought 5B got the job done. Go ahead. So, summary of the hearing officer's order, copies of which are on the table on the side. Reorganized within 90, no longer required to be members of a municipal association. Return 33 million, return 3 million, return 17 million, and then the real estate goes back to Health Trust, where it belonged. In addition to this, the Secretary of State signed settlement deals with Primex and School Care, both of which who were very cooperative. When the issues were raised, they negotiated with us. They'll return about $25 million to their member communities over the next few years. So the Bureau, with the Secretary's oversight, gained about $75 million for New Hampshire communities through this activity. Materials are on the website at the Secretary of State's office. If you Google Secretary of State New Hampshire, it'll get you there. Those are the actual web addresses. I think we have questions. Okay. Go
I
ahead.
just asked why these crooks aren't in jail right now.
Yes.
Because they should.
I'll assume that's rhetorical.
No, it's not.
No, I'd like to know why they're
No, this is New Hampshire.
Well, this isn't, I'm not a prosecutor, so it's not, and the secretary's not a criminal prosecutor.
Is
Go
there
ahead.
a mechanism to have another entity in New Hampshire prosecute them for what they've done?
I think the senior criminal prosecutor in the state is the Attorney General.
Would you call this financial fraud and a criminal activity?
Repeat the question for
Yeah,
everyone.
okay. Because the audience members don't have the microphone, let me try and repeat it. The question was, is this a financial fraud and is it criminal, essentially, is the question. I think that goes beyond the hearing officer's order, and unless the secretary wants to address it, I'm going to respectfully decline, because the Attorney General really is the senior criminal prosecuting authority in the state, and he's not in the Bureau. He's a separate branch or office of state government. Let's just work our way back.
Is it my understanding that the actual board of directors that were there were made to resign and cooperate with the Attorney General?
The question was, is the board that was there, were they made to resign? Were they made to cooperate with the Attorney General? The board hasn't changed in a significant way that's been in place from '08 to the present. That board is the same board that just voted to appeal this decision that condemns their conduct. Board members from the early point in '02, '03, many of them were respondents in our case, and we reached settlements with the ones that were respondents, with the exception of Mr. Curo. The hat? Yeah.
Before I ask my question, I'd like to say to Mr. Gardner, and I think I speak for everybody here, you are without a doubt the most respected public official in the state of New Hampshire. And my question, sir, as a retired Portsmouth firefighter who has for 15 years been taken advantage of, paying my full Blue Cross for my wife and I, not subsidized by the city, which is often misunderstood by residents. I asked one of our city councilors how they thought my refund would be handled, and was told by an individual, one elected individual who doesn't speak for the entire city, that he thought I would be on my own, that wasn't the city's responsibility. I wondered if anyone could comment how retirees will be treated in this, or how you would expect, what your thought. I'm not asking for a legal opinion, just some assurance that people in my position, this woman sitting in front of me who's been retired for twice the time I have and been taken advantage of for twice the time, are hoping to have some resolution personally. Thank you.
So the question, everyone probably heard that, is what happens to retirees and their refunds? I think that individuals who contribute, either as retirees or because their collective bargaining agreements require a partial contribution, have been the subject of a lot of concern on the part of the Bureau, starting from the release of Sandy's report in 09? 10. So it's an issue that all of us have been very concerned about. We had hoped and still hope that within the 30-day period that was up on the screen, we get to negotiate exactly how that works. On the Primex side, because they have a similar settlement agreement, the approach is to get the money to the municipality and then have the municipality essentially either refund or discount it back to the members of the collective bargaining units or the retirees. But it's not been decided for the LGC, and it may not at this point be decided till after an appeal is decided. Okay, let's go over here. The dark shirt, yeah?
All right. As a retired person,
Sorry.
Our contributions to LGC did not go to the city. It went from the retirement fund to them. So to me, it seems like it should come from it should be reimbursed the retirement, and then they should give us that. Also on the workman's comp, so much money is owed workman's comp. We as retirees could not get any money from the workman's comp. So we get a part of that also. It shouldn't be returned totally to the city because some of our money was going to workman's comp and it could not use workman's comp as retirees.
So the first was a comment about the retirees and how they get their refund.
We do not go to the city.
Yeah, no, I understand. And the second was a question about how people in the retiree situation get the refund of the money that went to the workers' comp subsidy. So I understand that you don't work through your former municipality, you work through the retirement system, so that's an issue that needs to be addressed. As far as the workers' comp subsidy, essentially what the hearing officer has ordered is a repatriation of the 17 million from the workers' comp program to health. When it gets to health, it is then a surplus, and as a surplus it gets returned to the various parties entitled to it. So it's a two-stepper, but it amounts to the same thing. Okay, so this gentleman was patient here.
Kind of goes along with theirs. I keep hearing about how money being returned back to the town, but you keep talking about members. The money from the town is paid to local governments under the health trust as part of our compensation package. So really, isn't that money belongs to the members? You know, in a contract, the town says, you know, we will pay this much on your behalf for your health insurance. To me, the towns aren't really members due to the fact that they don't. The city of Dover does not have health insurance for the city. They have health insurance for the members, for the people that work with it. It's not money. The members and the money that's paid from the town, isn't that part of their compensation?
So this is another question on the same topic of how you get essentially money back to the working individuals who were members of collective bargaining units. I think in the case of active employees, those employees contributed usually a percentage, 10%, 20%, whatever's negotiated, to the cost of their health care. And they probably were affected in other places in their contract because they negotiated that.
But the whole healthcare package, that's part of their compensation.
Yeah, no, let me just finish. But you personally, as an individual employee, don't buy the package directly from LGC. It's more of a town or municipality self-insuring with other towns and municipalities. So it's they who actually contracted with LGC. Now, they have a second contract with you where they promise we're only going to take 10% of the cost of healthcare from you, and because LGC did these maneuvers, they took 12% instead of 10%. And that's an issue that the municipalities, and we've talked through this on the Primex side. So Primex is discounting for the next few years premiums to its members, and its members have to discount for the health insurance, have to discount to the individual employees. It's not that big a problem with Primex because they're basically out of the health care insurance, and you don't, as individual employees, you don't pay for workers' comp, the town does. But you're right, it's very complicated, and there have been times when the firefighters raised issues about whose money is going into the subsidy. And LGC contended at the trial that the employee and retiree monies were set aside and weren't part of that contributed to the parent. Only the calculation that was supposed to go to figure out how much to hold aside was supposed to be done every 3 years, and I think we saw it done once back at the outset and not repeated on the 3-year schedule as it was supposed to be. So the real answer is, how much do you trust their calculation, basically? Yeah.
The question I have is, how do we go from $300 million to what, $24 million out of that?
Yeah.
So
Where'd the money go?
300. Okay. So the question is, how do we go from 300 million to it's actually 52 million coming back? Okay. So
1/6.
yeah. No. Okay. But before you beat us up, LGC does operate insurance companies, and so those companies pay out claims. And when we looked, we may not have agreed with the way LGC spent their administrative monies, but they weren't grossly out of line in that regard. They're somewhat within the industry standard. But most of that 300 million is member premiums, and most of the premiums get paid out for claims. It's just this extra retained earning bucket that was really the issue. And of that bucket, the hearing officer ruled that they need to hold so much in case essentially of a rainy day. He said it should be 50 million, not 86 million. We think that's actually a little rich, but that's the order on that point.
And do we get a chance to recoup any of the money that they misspent by fighting this legislation?
I would think that that's something that members need to raise with their board representatives. There is part of the order that says the LGC has to repay the costs that we incurred. So it's a double whammy. And someone should be asking the board about why that's not going to result in any changes to their operations. So, young woman in front of me.
Thank you. The state employees, active and retired, currently get their pharmaceutical benefit management services through the LGC, through a contract between the state of New Hampshire and the LGC. If there are any surplus dollars from that benefit, from that contract, they are supposed to be returned to the state of New Hampshire, where the state of New Hampshire annually liquidates any surplus in the health plan back to the state agencies, therefore back to the taxpayers. The funds are commingled at this point. We are trying to get to the point where we can identify through a very transparent way if any of the proceeds of our benefit were mingled with the town's benefit. And right now, LGC is spending thousands and thousands of dollars on a young law firm to block the legislation that would move us forward with further transparency. Not just in defense of this case, which none of our funds are supposed to be supporting that. So I'm wondering if you can tell us what the order will do for the state
don't think it's within your purview. Yeah, so let me, the question, which I won't try and repeat, was about what happens to state employees. A part of their health care relating to pharmacy care is managed by the LGC, and what happens to their refunds. This case was about the stateside operations of the local government center, the 5B side. The state pharmacy care isn't part of the 5B operations of the local government center. I mean, there is an unrelated separate statute that you asked about lobbying that says you can't lobby and receive appropriations unless you segregate the money. That's not in this case. That may be an issue that other people will look at, and as well the state pharmacy money. But that wasn't, I'm afraid, part of this case.
Just to be clear, my question wasn't asking about the return to state employees. My question was the excess funds owed back to the state of New Hampshire as part of the proceeds being diverted into this other Part B that we're talking about.
Okay. Let's get the back and we'll work our way. Yeah?
Question relative, I know that the order had something in there about not requiring membership to cities and towns, but I guess if I want the city of Portsmouth to no longer do business with the local government center, the health insurance trust, isn't there a no-compete contract with Anthem, the local government center, and the city of Portsmouth if they were to pull out?
Okay. So the question is there a what you call a no-compete or an exclusivity contract between Anthem and LGC, and in this case, Portsmouth? The answer is that LGC negotiated an exclusivity agreement with Anthem, with a couple of exceptions for the largest municipalities, Manchester and Nashua, so that if you're a municipality and you want to insure with Anthem, you pretty much have to go through the local government center.
So it was not addressed in this order?
That's not part of this order. Portsmouth isn't a party to that exclusivity. It's just that Portsmouth happens to use the LGC and thereby is bound. One of the things that is in the order is the LGC has a bar provision so that if you leave the LGC's insurance network, you can't come back for 2 years.
You made mention of the LGC calling like as an insurance company. They're actually an insurance pool, like a broker. They're not a company.
Not like a broker. The question is, is the LGC like an insurance pool or a broker? They're more like a pool of self-insurers.
Well, on another note, they were selling insurance illegally because they weren't licensed under the state as insurance agents. That's the way I believe it happens. Is that right?
The question was, are they selling insurance illegally because they're not licensed as insurance producers? I think under 5B they're exempted from the insurance laws. So that's the benefit they get by being a municipal risk pool. They don't have to abide by all the insurance regulations. Yeah, go ahead.
What is the status of the right to know issue? Are there current minutes now available to anyone that chooses to see them? Are the board of directors members' names available to the public?
So the question is, are the minutes of board meetings and board members' names available? They are. You can get them on the LGC website. There are minutes there. There are board members' names there. There are, the secretary was underestimating when he said 6 feet of documents. There are 20 boxes of documents, maybe half of which are minutes in evidence, and so they are all up, am I right, on the website? Just the transcript? Okay, so they're available as public documents, so you'd have to come physically and see them. So you could do that through the Bureau, but they're available, they're no longer confidential or non-public.
I read Hearing Officer Mitchell's report cover to cover, and then I hit some things that kind of struck me as a little bit unusual. He said they acted like landlord and tenant at the same time. And that